Okay, welcome everybody. Hello, we're doing form analysis. This is a review. We've done this in class, but I wanted to make a video for you because it's not well covered in the Jamar book, and I'm not sure it's covered at all in the Jamar book, and it's hard. So I want to kind of walk you through this and see where we are. We're going to do a little work in here, then we're going to take it on the road. Let's get our big word up here first, forum. Analysis. We're excited about this, so I'll put an exclamation point. All right, form analysis. What we're looking at here is government properties, different kinds of government properties, and how the First Amendment works on them. We're going to start with the traditional public forum. Traditional public forum. Traditional public forum, the court has said, is a place that, and here's the language of the court, time out of mind has been reserved for free speech. Now, what is this place? Well, things like sidewalks or streets or public parks are the typical locations, but there may be others. We don't really know. The touchstone here is whether the area, the government property, has been reserved for speech for a long, long time. Again, time out of mind. Parks, sidewalks, and streets, the court says, have been. Those are traditional public forums. On the other end of the spectrum, we have non-public forums. Non-public forums. Non-public forums are the exact opposite of traditional public forums. Non-public forums are government property that have never been open to free speech. These are places like, maybe most obviously, prisons, or military bases, or government office buildings, or schools, right? These places have a particular purpose, and what the court has said is, if the government wishes, the government can restrict speech in those locations for the purpose for which the locations are intended. Government office building, well, government employees do have some free speech rights, and we'll cover that as well. But as a general matter, you can't hold a protest in a government office building. The government office building is not open to free speech in the same way that the public park right outside of the government office building might be. These are non-public forums. Now, traditional public forum, non-public forum, they come with two different rules. Let's go through those rules before we complicate the picture. The traditional public forum, the government can regulate using time, place, and manner regulations of speech that are content neutral and satisfy that time, place, and manner intermediate level scrutiny test. Now, we've already been through the test in a different context. It's the same test here, public forum, time, place, manner test. What's important for our purposes is that the regulation in the traditional public forum has to be content neutral. In the non-public forum, the rule's a little bit different. In the non-public forum, the government can regulate speech, but it can't regulate it in a way that is viewpoint-based. So the government regulation in a non-public forum has to be viewpoint neutral. That begs the question, of course, what's the difference between content-based speech and viewpoint-based speech? Well, I'll say very briefly now, but then we're going to illustrate it a little bit later in the video and go through this in a little more careful detail and actually drill down a little bit into the difference. So, a content of speech might be something like political speech or religious speech or speech about your school or speech about your family, something like that. Viewpoint-based speech is a viewpoint on a content. So if the content of speech is, say, political speech, viewpoint-based speech might be Republican speech or Democrat speech or Green Party speech or even politically independent speech. If the content is religion, The viewpoint might be Christian speech, or Jewish speech, or Buddhist speech, or Islamic speech, or atheist speech. You get the idea. Now, that kind of oversimplifies things, as we'll see later in the video, but for now I think that'll do, the difference between content-based and viewpoint-based. Now, let's mess up the picture a little bit. We know there's a traditional public forum and we know there's a non-public forum, but a couple of things can happen that we need to watch out for. One is when the government opens up a non-public forum entirely. The government can do that. The government can take a non-public forum and open it up and designate it as a public forum. In other words, take a non-public forum and designate it as a public forum. We call this a designated public forum. What's the rule for designated public forum? Well, maybe you won't be surprised to learn that it's exactly the same rule as for a traditional public forum. It's that time, place, and manner intermediate scrutiny test, but again, the key part that we're concerned about now is the content neutrality of the regulation. So a government that might take, for example, a school or a government hospital or maybe a government office building that's no longer being used for that purpose, and transform it into a public forum, an area for free speech. Any comers, anytime. Come and have your speech, that's perfectly fine. We call that a designated public forum, and we need to look for the time, place, and manner test for any government regulation, the intermediate scrutiny, and content neutrality. The other thing the government might do with a non-public forum is open it up, not entirely to speech, as it did in the designated public forum, but open it up maybe just a wee little bit to speech. When the government does that, it's creating what's called a limited public forum. Limited public forum. Now, let me just say something about the language. The designated, limited, this can all be a little confusing. I'm using the language of the court itself, and so it's important to understand designated versus limited. Designated simply means you're going full force public forum. Limited means you're opening yourself up a wee little bit to some speech, but not all speech. When the government opens up a building, say a school, as a limited public forum and maybe allows civic groups to come in and to use the school building after hours, the rule is the same as for a non-public forum. The government regulation has to be viewpoint neutral. So if a public school decides, you know what, the community really could use our space after hours, after we're done with it, why don't we just invite the community in? First come, first serve, perfectly fine. If the government does that, as it turns out, the government can discriminate by content, but not by viewpoint. So, for example, if the government did that, if the government created a limited public forum in a school or maybe the side of a bus or on the side of a subway or some other non-public forum, the government could say no political speech, but we will allow commercial speech. What it couldn't do is say no Republican speech, but we will allow Democrat speech. The reason why is because politics is a content, and in a limited public forum, you can discriminate. The government can discriminate by content, but it can't discriminate by viewpoint. That's the rule. So, traditional public forum, non-public forum. Non-public forum turning into a public forum by designation gets the same content-based rule. Non-public forum turning into a limited public forum gets the viewpoint-based rule. Now, we still have a big problem here, and that's what I hope we're going to try to go solve. That is, what's the difference between content-based and viewpoint-based speech? All right, why don't you guys come with us, and we're going to go take this on the road and see what we can figure out. Okay, hey everybody. Hey, here we are. So this is new. We're in the State Street lobby. You guys want to get, just for proof, John Marshall Law School. We see that, right? Okay, State Street lobby. We're going to go outside. Come with me. Okay, come on this way. It's cold out today, but I still talked my friends Joe and Johan into coming and doing this video with us out here in the park. So we're walking down State Street. We're going to the public park over here. I want to show you guys a couple of things. Okay, there's a ton of stuff out on the street that has everything to do with form analysis. We're going to take it one step at a time. We're going to start with the easy and then get to the more interesting stuff. Come on, let's do it. Okay, here we are in this public park. You guys are familiar, you probably hang out here, right? So this is a public park right outside the law school. This is one of those places that time out of mind has been reserved for public speech, a public park. The government can't regulate speech in a public park except in an ordinary time, place, and manner restriction, right? And it's gotta be content neutral. So, for example, the government can say you can only speak in the public park between, say, 9 a.m. and 6 p.m. No protests in the park except between 9 a.m. and 6 p.m. The reason why? Well, that's a content neutral rule on speech, right? But what the government can't do is say, for example, no political speech in the park. So, for example, if I had, it's a really lame poster, and I'm sorry about that, but check it out. If I had this poster, and I want to have a political discussion in the park, right? This is what I want to do. And the government comes along, they say you can't have a political discussion in the park. Well, that's invalid, they can't do that. But even more so, if I wanted to have a viewpoint-based discussion in the park, this is what I want. They can't do that either, right? Viewpoint is a kind of content, so the government can't regulate by that either. We'll see that more in a second. But in the meantime, why don't you come with me? I want to show you a couple of other things too. It's really cool. First, guys, check that out. You see the CTA trains up there? What do you think? The side of the CTA trains, are they public forums or are they non-public forums? Can the government regulate speech on the side of CTA trains or not? Well, they're probably non-public forums, right? In fact, we can say with certainty they're non-public forums. What that means is if the government wants to regulate speech on the side of the CTA train, it can say speech, you can buy advertisement on the side of the CTA train for commercial purposes, but not political purposes, right? That's a content-based restriction, and they can regulate a non-public forum based on content. But what they can't do is say Republicans can buy ads, but Democrats can't, right? Same principle. Let's go check something else out. I'll show you this. Bus, same thing. Check that out. Get to the center of architecture for the architecture center on the back of that bus. Well, you know what the bus probably did? They've probably said you can put commercial advertisement on the bus, but you can't put political advertisement on the bus. That's okay in a non-public forum, the side of a bus. And remember, the bus is government property. It's public transportation. So that's why they can regulate on the bus. You want to see another example? Come here. Check this out. You guys ride divvy bikes? You know about divvy bikes? Okay, so this is a divvy bike. It's government property. Look at the advertisement on it, right? An advertisement for Blue Cross Blue Shield. Divvy probably has a rule that says you can put commercial advertisement on the side of our bikes. These are non-public forums, but no political advertisement. And they probably have some sort of content neutral rule that says something like first come, first serve. You got to pay a certain amount of money for your advertisement, that kind of thing. But what they couldn't do is they couldn't say you can put a pro health insurance sign on the side of the bike, but you can't put an anti-health insurance sign on the side of the bike. Why? Well, you already know why. That's a viewpoint-based restriction on speech. Let me show you just one other thing. Come here. Can you guys get a shot of that? So that's the public library, right? The Harold Washington Center. We know that public library. What do you think the public library is? Public forum? Non-public forum? Well, here's the thing. The sidewalks outside the public library are probably a public forum. Inside the public library, probably a non-public forum. And the reason why is because the library is designed for the purpose of reading and looking at books, right? You can't have protests in a library when you're reading and looking at books. So the government could discriminate by content in the library, but it couldn't discriminate by viewpoint in the non-public forum of the library. Okay, let's go back to the school. Subway stations, right? Same thing, non-public forum. You go into a subway station, you might see particular kinds of speech in a subway station. Probably not the sort of thing time out of mind is reserved to public speech. They're probably non-public forums, which again means the government can discriminate by content. We can allow commercial advertising. We can allow, say, advertising for civics purposes or civil society purposes, but not for political purposes. What they can't do is discriminate by viewpoint. So they can't say something like, no Republican speech, but you can have Democratic speech, or no pro-choice speech, but no pro-choice speech, but yes, pro-life speech, that kind of thing. Here we are, we're on the sidewalk outside of John Marshall Law School. You can get a picture of the school, right? And here's my friend, you're Eric?
Yes, Eric.
Eric, Steve, nice to meet you, Eric.
Meet
How you doing? Okay, so Eric's gonna help us out with this. We're on a sidewalk. This is one of those places, time out of mind, has been reserved for public speech. It's a public forum. What that means is the government can't regulate it. Now my friend Eric here, he's not a government officer, right? He's a John Marshall officer, and John Marshall is a private organization, which means I don't have any free speech rights against Eric. The First Amendment doesn't apply, right? Remember the state actor doctrine. But let's pretend for a second that he is a government officer, okay? And I'm gonna go back to my signs. What I'm gonna say is, let's talk politics out here on the sidewalk, right? Now Eric's gonna come up and Eric's gonna say, hey dude, you can't talk politics on the sidewalk.
Hey dude, you cannot talk politics on the sidewalk.
Okay, did you get that? Say it a little louder into the mic.
Hey dude, you cannot talk politics on the sidewalk.
Okay, he said I can't talk politics on the sidewalk. And he's gonna take my sign and he's gonna arrest me, right? Oh, sweet, really?
No, I'm just, you wanted it to go through or what?
Oh yeah, yeah, for sure. You have the keys, right?
Yes, I do.
Okay. Okay, awesome. So look, I was making a political speech and I'm arrested. That's a violation of the First Amendment. No content-based restriction on speech in the traditional public forum. Even more so, it's okay, I got it. Remember my other sign? You wanna help me out? Okay. Officers don't usually do this, but today they are. So this is viewpoint-based restriction on speech. Eric, tell me I can't talk democratic politics on speech. I can't talk democratic socialist politics.
You cannot talk democratic social politics.
Yeah, did you get that? You can't, okay, good. And I'm still arrested, right? Viewpoint-based restriction, even worse than content. Okay. How often do you guys get to do this?
On video shoots?
No,
Or
handcuffs.
trainings, and if we have to go ahead and put it on someone, then we go ahead and put it on someone. But we usually
Really?
carry our keys with us already, but I
Hey.
was ready to head out, and they told me come down for a shoot photo.
Dude, I've got some students that I would like to see you put these on. Would you do that for me?
Put on some students?
Yeah.
I would have to go ahead and let my boss first know if it's okay to go ahead and put
Right.
on the students real quick.
Where you got to get permission for that kind of thing. It's not
Yeah,
enough for
I
a
mean-
professor to tell you?
Pretty much.
No?
We would have to let him know what we're going to be doing for the video shoots.
All right, all right. All right, awesome guys, thanks.
All
I
right.
really appreciate it.
No
Thanks for
problem.
getting me out. Hey, how you doing? Good. Yeah, we're just doing First Amendment forum analysis. Yeah, on the street.
That's awesome.
Yeah, it's pretty awesome, right?
You're learning at its fun.
Yeah, exactly. Okay, guys. Check this out, right? So here's an advertisement for New Buffalo, Michigan. Great place. I love New Buffalo, Michigan. But look where it is. This is on government property, non-public forum. What's the government rule? Well, we don't know what it is, but we might reasonably guess that the government says you can do commercial advertising or maybe something like tourist advertising on the bus stop, but you can't do religious advertising, for example. Now, when we start talking about religious advertising, things are going to go a little bit more complicated. We're going to go inside and take a look at that. But for now, non-public forum, and there's probably a government rule that says it's okay to do commercial advertising, not okay to do other content-based advertising, and that's perfectly fine. What the government rule couldn't say is you can advertise for, say, New Buffalo, but you can't advertise for Las Vegas, right? Because that would be viewpoint-based. So it can't make viewpoint-based regulations in the non-public forum. Okay, you guys have been really, really good. I just want to do one more thing because it's starting to get cold out here. Take a look at that. Those two big black buildings right there. Those are the federal courts, right? Non-public forum. The sidewalks on the outside of them, that park by the post office, Austin Park over there, right? Those are public forums. But inside that building, that's a government office building, non-public forum. In the park outside, the government can't regulate speech by content. Inside, it can, but it can't regulate it by viewpoint. Okay, I'll tell you what, I think we've been out here long enough. You guys want to go inside? You ready? Let's do it, okay. Okay, hey everybody, so here we are in a classroom at John Marshall Law School, and we're going to be quiet because that's what you do in a classroom. Now we're at John Marshall Law School, which is a private school, so there's no First Amendment protection here. Again, remember the state actor doctrine, but let's pretend for a minute that we're not. Let's pretend for a minute instead that we're in a public school, a public primary school, K-12 school, and that they've opened themselves up to us after hours for civics organizations to have their meetings in the available classrooms. The rule is first come, first serve. It's got to be after hours, after school. Any night of the week is fine, and you can reserve it in a 1 hour block. Now you might say, well, is that a good regulation? Is that a valid regulation under the First Amendment? Answer, sure it is, right? Content neutral. It meets all the requirements. It meets intermediate scrutiny because the school has uses for the classroom as well, and so can limit it. It doesn't have to open it up entirely. And so that rule is going to be perfectly fine. Now, if the school wants to discriminate by content because it's a limited public forum, no worries. So let's go back to my signs, right? Let's talk politics, right? The school can say, no politics talk in school. This is for civics organizations, but not political organizations, so you can't talk politics. It's perfectly fine. But what if I want to have my social democratic talk here at school, and the school says you can talk politics, but you can't talk social democratic politics? Well, that's a viewpoint-based regulation. A viewpoint-based regulation in a limited public forum like our classroom, the one that we're in, that's invalid, so the school can't discriminate that way. Now, all that seems really easy, right, so far. And in fact, next whiteboard here, just kind of remind ourselves where we are. So, public forum, content neutral, non-public forum, viewpoint neutral is the rule. Okay, now what's really hard about this, other than what we've done so far, is the difference between viewpoint neutrality and content neutrality. These things are going to spill into each other at some point, and we got to worry about that and figure out when are we dealing with content, when are we dealing with viewpoint. Here's the case. It's called Lamb's Chapel. We're going to take a look at this in a second, but let me give you the setup. So a school decides after hours that it's going to open itself up to civics groups, just like our hypothetical school did in this case. But it's not going to allow religious talk in the schools. I'll show you the rule here in a second. I've got the text here. Not going to allow religious talk in the schools. Now, this is a limited public forum. We think the rule is viewpoint neutrality, and the government thinks that it's discriminating by content, not viewpoint, right? No religious speech, but we can have any other kind of speech in the classroom. The government says, well, that's a content-based restriction, not a viewpoint-based restriction, so no worries, even in the non-public forum. You might say, why in the world would government have this kind of rule? a lot of schools think that if they allow religious speech in the school, they might violate the Establishment Clause. But we're going to see in a couple of classes that that's not so. You can allow some religious talk in the schools without violating the Establishment Clause. Indeed, under the Free Exercise Clause and the Establishment Clause, a school probably has to allow some religious speech in the classroom if it's allowing other kinds of speech. For First Amendment free speech purposes, for sure it does. Let's take a look at the text. This is a case called Lamb's Chapel. You can see the case title right there. It's a 1992 case from the United States Supreme Court, and this is the citation, 508 U.S. 384. You don't have to read this case if you don't want to. I'm going to take you through it here, but if you want to read it, that's perfectly fine. Okay, so here's the rule. New York education law authorizes school boards to adopt reasonable regulations for the use of school property for 10 specified purposes, social, civic, and recreational meetings and entertainment, but not religion, no religious purposes. The court in Lamb's Chapel went on to say that in that context, the discrimination against religion is actually a viewpoint-based discrimination, not a content-based discrimination. Let me find the text for you to show you exactly why. Check this out. There's no suggestion from the courts below or from the district or the state that a lecture or film about child rearing and family values, which is the general content, would not be used for social or civic purposes otherwise permitted by the school rule, Rule 10. That subject matter is not one that the district has placed off limits to any and all speakers, nor is there any indication in the record before us that the application to exhibit the particular film series involved here was or would have been denied for any reason other than the fact that the presentation would have been from a religious perspective, you see. What the court's saying, and it goes on here to say, that you can have a content of speech, family values, and a religious perspective on that content. So we've previously thought about religion as a content of speech, but in this context, it's actually a viewpoint of speech. And in Lamb's Chapel, what the court said is the government regulation excluding that religious viewpoint on family values, that's invalid. Let me quickly give you another case because we're going to get kicked out by another class here. Professor Bond is my friend, so I'm not too worried about it, but I'm worried a little bit. Okay, this case, McCullen versus Coakley. The citation is incomplete, it's 573, because it's a recent case, it's 2014. Let me tell you what the statute in the case says. No person shall knowingly enter or remain on a public way or sidewalk adjacent to a reproductive health care facility, that is an abortion provider, within a radius of 35 feet of any portion of an entrance, exit, or driveway of a reproductive health care facility or within the area of a rectangular care created by extending, this kind of goes on from there, but the idea is we're going to create a kind of free speech zone around the abortion clinic. And the reason that the state did this, was putatively the reason was to allow free access in and out of the clinic without being hassled by anybody. But really, I think what the clinic is concerned about is anti-abortion protesters prohibiting access to the clinic by women who are seeking an abortion. Now, this is a traditional public forum, the sidewalk outside the abortion provider. And so we think that if this is content-based, then the regulation is going to fail. The court goes on here to say this is not content-based, even though kind of everybody knows why the state set up the free speech zone in order so that women can gain free access to the abortion without anti-abortion protesters impeding their access. That's not only a content, that's a viewpoint. Even so, the court said that the rule on the face of it is content and viewpoint neutral. Here's why. It's true that by limiting the buffer zones to abortion clinics, the act has the inevitable effect of restricting abortion-related speech more than speech on other subjects. But a facially neutral law does not become content-based simply because it may disproportionately affect speech on certain topics. On the contrary, a regulation that serves purposes unrelated to the content of expression is deemed neutral, even if it has an incidental effect on some speakers or messages, but not others. The court then goes on to say that Massachusetts adopted the law for neutral reasons. What neutral reasons? Well, its stated purpose is to increase forthwith public safety at reproductive health care facilities. Respondents have articulated similar purposes before this court, namely public safety, patient access, and unobstructed use of public sidewalks and roadways. That's enough for the court. If that's the stated reason, the court's going to treat it as a content-neutral regulation in this traditional public forum. All right, we're going to wrap up because we're going to get kicked out of here in a second. But I want to thank you guys. Thank you guys. Thanks to Joe and Johan who've been great through this, and of course our security guards who locked me up earlier. And I hope this answers questions on public forum analysis. Thanks.